Are there damage caps in Pennsylvania for medical malpractice lawsuits? A lot of our clients, when they come to us, ask, what's our case worth? And with that question comes the concept of, well, how much potential damages could you recover in the state of Pennsylvania? As a general premise, there are no specific caps on damages in Pennsylvania, which is very fortunate for the patients in Pennsylvania because many other states have very brutal and unfair caps on the damages that can be recovered in Pennsylvania. However, we are governed by a statute that is related to medical malpractice. It's called the Medical Cost and Reduction of Error Act, and it does speak to the amounts and levels of insurance that are available to injured patients when medical malpractice happens. The way it works in Pennsylvania is that doctors and hospitals pay for a primary level of insurance, and that amount is $500,000 of insurance. So if a doctor injures you, right off the bat, they have a primary level of coverage of up to $500,000. By obtaining and having in place that level of insurance, the state of Pennsylvania, the Commonwealth of Pennsylvania, provides the doctor or the hospital an additional $500,000 on top of that for a total of $1 million. But over and above that, what you'll typically find is that the services in question were in one way or another provided through a health system or a practice group, which in turn is going to have even more insurance applicable to your particular claim. So it's a rare case that we encounter where there's insufficient insurance to cover the damages in your case. The only scenarios in which there are real caps is if you get into situations involving either life care plans or punitive damages. Under the MCARE Act, when it comes to punitive damages, the most that can be recovered is essentially double whatever the compensatory award was. So let's say hypothetically, your lawyer takes your medical malpractice case to trial, you win, the jury awards you $1 million for your compensatory damages, whether that's pain and suffering or lost income or so forth. And then they also enter, say, $10 million of punitive damages because they were so upset by the conduct in question. Well, in that scenario, by statute, the most that you would be able to recover, what you would be capped at, is $2 million total dollars. In the life care plan setting, life care plans are medical projections that detail the amount of care that you or your loved one is going to need for the rest of their life to take care of them for the injuries caused by the medical malpractice. In Pennsylvania, though it's not a specific cap, if a jury, say, awarded you $20 million and that was the total cost of your life care plan, the defendants, the insurance companies representing the doctors and hospitals, by law are entitled to purchase an annuity to pay for that. And by doing that, it costs them much less money to actually pay for your life care plan. So those are the only real ways in which there are caps. But otherwise, as far as your pain, your suffering, inconvenience, loss of the pleasures of life, the amount that you can recover for lost income, the amount that you can recover for past medical bills, there are no caps in the Commonwealth of Pennsylvania.